you'll see that the signature underneath is Camille Labchuk. I'm not Camille. For those of you who know her, she is the dynamo director of an organization called Animal Justice. And that's an organization of lawyers in Canada who have organized specifically to advocate for animals. And Camille did this presentation in Moncton a couple of days ago. And so rather than reinvent the wheel, she agreed to let me use her slideshow. So thank you to Camille. And I think you'll find that it hits all the points that I hope are useful in this conversation. So I just wanted to say one point by way of introduction. I've been a lawyer now for almost 27 years. And much of that time I've spent advocating for animals. And I have found that what has been the most effective use of my legal background has very rarely been going to court and trying to make an argument for animals, or going to meet with government officials and trying to get them to pass more progressive laws. What I have found to be the most beneficial use of my legal skills, frankly, is having conversations just like this one with groups of people so that I can share my perspective on what the limitations are when it comes to animals in the law. Because I'm sure this has happened to you. Every once in a while, you hear a terrible story in the news about some ridiculous act of violence that has happened to an animal. And you think to yourself, oh my God, like surely this must be illegal. I've had so many calls like that. Did you hear about this? You know, what law did they break? What can we do? And so what I have found to be my most effective skill is, frankly, unfortunately, disabusing people of their expectation that the law is there to help animals, or that any law really, frankly, very much does, because of how the legal system is designed. Now, it sounds like a bit of a negative thing on a Friday afternoon to say, gee, you know, the law really sucks, it doesn't do very much for animals. But I actually see it as a positive, because knowledge is power. And so when we have an understanding of how the law really works, we are better in a position to respond when politicians want to throw some crappy regulatory amendment and say, here, all you people who care about exotic pets, off you go, here's your little regulation, that'll solve your problems. You have a better understanding of why it doesn't. When you have an understanding of what are the limitations that are written right into the law to protect those who own animals and want to exploit them much more than the animals themselves, then you're in a much better position to respond in those conversations and to come up with an informed way of figuring out what are the legal solutions to the problems we've been hearing about all day. So there's a long version and a short version of how to deal with the law when it comes to animals. And it is happy hour on a Friday afternoon before a long weekend. So I'm not going to try and inflict the long version on you. But let me say this as a short version. The predicament that animals face in our legal system goes back tens of thousands of years. Why? Because in that time, prehistory, pre-law, we began our process of exploiting animals for very many of the same reasons that we continue many millennia later to continue to exploit them: for food, for clothing, for protection. Of course, we've added many reasons in thousands of years. But back in the day, many thousands of years ago, it's probably the case that few people paused to say, is it acceptable? Is it okay to do this to an animal, and if so, why? The way we have started to do in more modern times. And then as time went on and we started to develop a legal system, we started to decide that we've got to come up with actual rules to codify our relationship with one another. And we developed a legal system, and particularly in the West, when we developed our Western legal system, which is very highly focused, not exclusively, but very highly focused on our rights in respect of property, right? Think about what law is for a moment. Family law, the family's splitting up, we're splitting up the stuff. Somebody died, who gets the stuff? Criminal law, you broke into my house and took my stuff. Corporate law, we're making lots of profits, who gets the stuff? You know, so our legal system is very occupied with property. Whose is it? Well, when the notions of private property were being conceived several hundred years ago, animals were at the very center of the concern, because at the time there was a real strong problem, not in respect of the welfare of the animals themselves, but of the people who were fighting over their interests in animals. And we had to figure out a principled way to share our interest in exploiting animals. So for example, a problem at the time, what if you are hunting an animal, you're pursuing her, you finally shoot her, and then she falls and dies? Who does that animal belong to? The hunter who chased and shot her, or the landowner on whose land she finally collapses and dies? This was a legal dispute. Seal hunters are out tracking seals on an ice floe. They get onto the ice floe, they use their hack-a-pick to attack the seals on the floe, but they don't have time to stay and skin them because they have to move on to find other seals, so they leave. The ice floe moves along, another group of sealers find it, and they claim the seals for themselves. Who do the seals belong to? The ones who smashed them on the head and disabled them in the first place, or the ones who found them later? These were the concerns of law for hundreds of years. Not the animal themselves, but who does the animal belong to? Now, things have changed. In recent years, science has taught us a lot about animals, hasn't it? Science has revealed to us an incredible biological kinship, where we used to be able to say, oh, they're categorically different than we are. It's much harder to say that now. We know so much about how they feel. We're hearing this afternoon about reptiles, insects, animals that even people who care about animals have for a long time dismissed. But science is making that harder because we're learning more and more about how similar we really are. And the law has to respond. It hasn't yet, but it's going to. So, as an overview for where we are in the scheme of things, there was something else. There's one point lingering in my head that I was going to say. Oh, I missed the main point. The very main point, I'm sorry, was all about, so why did I say all of that? Because when our legal system was organizing itself and we were creating foundational ideas, such as how to allocate our interests in property, how to even allocate all natural resources, right? How do we find a principled way to share animals and other natural resources amongst one another? Animals were at the key. Animals were part of the very essence of the definition when we defined our property laws. In fact, when you look at Latin words and Spanish words for money, for economy, you'll find animal at the root. So from the very beginning, when our legal system started to look at interests in property and how to allocate them, animals were categorized as property. And humans, all of us in this room, are property owners. Now, what does that mean? What that means is that when I walk into court to try and make an argument to a judge about the interests of an animal, I may just as well be talking to the judge about the interests of my television set or my dirty socks. Because in law, they're not that dirty, but my worn socks. Because in law, an animal is a thing, and a person is an owner of things. So before we even ever set foot in that courtroom, to talk to a judge about a conflict between the two, we know pretty well how that conflict is going to be resolved by how we have categorized the parties in the first place. One is a thing, and the other is its owner. So that goes a long way to making the rest of my story a little bit shorter. And now let me turn to the overview of the different areas of law that come up in respect of exotics. So we've got 4 different areas. Canadian laws applicable to the trade in exotics arise at the international level, the federal level, the provincial level, the municipal level. But we will find that the existing law largely fails to protect individual exotic animals, and in fact, in most cases, is not even concerned with their interests at all. So for example, internationally, you've all heard of CITES. CITES is the Convention on the International Trade in Endangered Species of Wild Fauna and Flora. So what that international treaty does is it tries to ensure that international trade in wild animals wild animals and plants doesn't threaten their survival. So there are several appendices, and animals get put on different appendices, and then the trade in those animals is regulated to some degree depending on how threatened or endangered they are. The idea is to protect at-risk populations, not individuals. So there are import-export permits for CITES-listed species, and uses of them are allowed depending on which appendix you're on, in some cases for non-commercial uses, in other cases for commercial uses. But the focus is on whether the trade will threaten the species' survival. There is no attention, it's not an aspect of CITES, to look at what happens to the individual who is in trade, the life experience of the elephant who ends up in the circus, or the tiger who lives in a zoo enclosure. It's only the population and their strengths. Now, when Canada signs on to an international treaty, in order for it to become law within the country, we have to pass our own legislation to implement it. So to implement CITES, we have passed WAPREDA. And if that seems like a ridiculous acronym, look at the actual name of the legislation: Wild Animal and Plant Protection and Regulation of International and Interprovincial Trade Act. So that legislation implements CITES, and it creates the system of import-export permits for at-risk species. And it does touch on some exotic pets. So common examples, most parrots are covered, many lizards, snakes and turtles, hybrid cats, some fishes. And I say fishes quite deliberately as a nod to Jonathan Balcom, who actually had to leave a little bit earlier. But he makes the point when he shares his expertise in fishes about how when we talk about fish, in the traditional way we use that word, it's a way of sort of losing the individuals. When we say fish, it's this large, anomalous, sort of nameless, faceless group that we don't have to think about. And so he says that he uses the word fishes because it seems to, if even subtly imply that there's a collection of individuals here. It's not just this amorphous group. So I'm trying to say fishes. It feels a bit awkward at first, but then it's normal. So back to WAPREDA. So WAPREDA also does not specify anything about the conditions that the animal has to live in once the animal enters Canada. And I want to pause here briefly with one more language comment in addition to fishes. I made a mistake when I was reviewing these slides, and Camille made the mistake when she was putting the slides together in using the language that we so often hear in respect of animals. And you see it in this phrase, and I invite you to look at that phrase and see if there's any language there that jumps out at you as a concern. So we know that animals are considered property in our law, or products, I believe, as Cliff referred to them earlier. And aren't we perpetuating that very categorization when we refer to an animal as it? Isn't it for things? My dirty socks, my television, my car, my computer, it, right? So I invite all of us, because language is symbolic of meaning, like language is symbolic of, well, it is meaning. Language conveys ideas directly and indirectly, I guess is what I was trying to say. So when we use the word it, as we all do, just casually because it's so normal, this isn't meant as a criticism, we are saying an animal is a thing. And if we pause for a moment and think, animals have genders just like the rest of us in this room, so why do we not speak of them in that way? So, but it slips through, as it did for both of us here. So I invite you to think about the next time whether you want to use the word it or perhaps he, she might work. And just to finalize the points, in respect of WAPREDA, as it is in many cases when you're looking at international trade, captive bred animals are much easier to import than animals that were wild caught. Another federal law that comes up in this domain is SARA, the Species at Risk Act, which is also concerned with populations of animals and protecting species and populations that are in danger. So it protects some Canadian wildlife species that are endangered or threatened. And some is an important word there, because anybody who's been involved in this work will realize quite what a difficult political act. It's not just science that is involved in getting animals listed on these endangered or threatened lists, right? There's quite an act of politics behind it, because when you think of the implications, the limitations to industry and development when an animal or a plant is put on this list, just because science says they should be doesn't mean politically they're going to get there. It's a two-part process, the latter part being hidden, much more obscure, and often more difficult to pass. But at least we have it there. It's something we're working on, and the Species at Risk Act prohibits the capture of wild animals from species that are protected, that have made it to the list, and captive bred animals, though, are largely exempt. Another area of federal law that has the potential to be relevant is we have the Health of Animals Act, and under that act we have federal regulations, the Health of Animals regulations. These are the ones that are really relevant in respect of agriculture, but they have broader application. So the CFIA, which is the Canadian Food Inspection Agency, requires permits for the import of some animals into Canada. Reptiles and amphibians do not need any permits, but turtles and tortoises do, or as the exception, turtles and tortoises do. Birds often require permits. Primates cannot be imported for personal use, but zoos can import them for captivity. Researchers can import them to be used in research. But as you know, if you've seen shows on Customs and Border Patrol, only a fraction of shipments are ever inspected, and many animals are found, even though it's only ever a tiny amount of inspection that ever gets done in general, let alone focusing in respect of animals. When those animals are found, they raise a host of other problems, because what then do border security do with these animals who are now in limbo? So there's a lot of complication. The last area of federal law that's relevant in this area is the criminal law. So in Canada, our criminal law is federal, meaning it's the same criminal code that applies all across the country. The criminal law is administered differently from province to province, but the laws themselves apply the same all the way across Canada. And we have a couple of provisions in our criminal code that deal with animal cruelty. They were in our original criminal code. In fact, the provisions that we have date largely back to the 19th century. They've been amended a couple of times, but the essence is really from the 19th century. And the two main provisions are the ones that you see there. So we have a prohibition against causing unnecessary pain, suffering, or injury to an animal, or bird, actually it says. And then we have a prohibition against abandoning a captive animal in distress, or willfully neglecting the animal, or failing to provide suitable and adequate food, water, shelter, and care. So there are some problems with relying on the criminal law to protect the welfare of animals in any meaningful way. And the first one is one that, that I alluded to in the beginning, the long talk, even though I promised you not a long talk, about where our laws come from and the essence of animal property, and how this gets snuck in as an assumption into our laws. We don't have laws that say animals are property, you can exploit them for your own purposes however you want. We don't need laws to say that. They say it in a subtle, indirect way. So if you look at that first provision, 445.1, superficially, when you're tired and it's late and it's hot on a Friday afternoon, you think, nah, maybe that looks pretty good. But if you spend just a second looking at it and thinking about it, what do you see? If it is prohibited to cause unnecessary pain and suffering to an animal, that means it's not prohibited to cause necessary pain and suffering to an animal, right? When is it necessary for an animal to suffer? We wrote the law, right? We interpreted the law. We use the animals. It's necessary for an animal to suffer whenever we say so, whenever we decide. We wrote the law. So it looks good on the surface, but we see written right into the law is permission that we've granted ourselves to hurt an animal whenever we see fit. But there's other issues, not just language. Criminal law is remedial, not preventative, which is to say we're all supposed to follow the law. That's why we have these rules. But criminal law doesn't respond until the law's been broken. So, how do we find out that the law's been broken? Most people who have pets have them in the privacy of their own home. Who sees what's happening there? How do we know? So you have to have, the animal can't tell us what's happening to her, so you have to have a witness to some harm being done to the animal. And then that witness has to be willing to come forward and tell somebody about it. And then that somebody that the witness tells, whether it's the Humane Society or the police, has to have the resources and the interest. Come on, we got a lot of real crimes to fight here. To respond and to do something about it. And they have to have the expertise. And they have to be funded enough to have people ready to come and respond to all of these calls and to have a veterinarian who understands about all the different reptiles that we're hearing about today and all the other different species to know what they're seeing when they see an animal in trouble. You have to have a crown who understands animal cruelty laws, who doesn't think there are more important real crimes to fight. So I don't have current statistics with me, but I've spent many years going through the process of working with humane societies trying to get amendments to our criminal code. We're in like decade 3 now, I think, of trying to get those amendments. It's not actually funny, but you gotta laugh. So it's laugh or cry. So humane societies will show you, so from just the complaints that come in the first place, right? So somebody sees that there's a problem and somebody's willing to come forward. So from a complaint to get to the Humane Society, which is already a tiny fraction of the incidents that are out there, to make its way through all of these processes, to actually get to court, to actually get a conviction, it's a 0.00 decimal point. Well, that's not very grammatical, but you get my point. It's a very tiny fraction of the complaints that are even made that ultimately end up ever getting prosecuted or ever getting convictions. There are so many hurdles along the way. And then, of course, you come, if you even get all the way, you come before a judge who thinks, in many cases, it's not true of everybody, come on, you know, we're going to attach a criminal stigma to somebody because they didn't give their lizard a big enough enclosure. We're going to make a criminal out of this person. You know, aren't there real crimes to fight? There are some progressive judges who are starting to see animal cases differently, but by and large, it's a real hurdle. It's just an animal. And probably you already have encountered that attitude, which is why you're in this room today. So that brings me to provincial law. Every province has its own animal welfare legislation. In Ontario, we have the Ontario Society for the Prevention of Cruelty to Animals Act. So it has some interesting components. That legislation went through quite a serious revision in 2008. And there were some really great developments. So for example, we have in Ontario not just the negative duty, the law in respect of the negative, which is the first one you see, that you shouldn't cause an animal, or you can't cause an animal or permit an animal to be in distress. It's a negative duty. But we are one of few jurisdictions, although there are more and more coming, who also have positive duties. This is something that was added in 2008, that you have to comply with standards of care. And there are regulations dealing with standards of care. So there were some really fantastic developments that came when the OSPC Act was amended in 2008. However, what the legislature gave on one hand, it took with the other. Because in implementing these and some other really positive aspects, it almost entirely undermined them by introducing into the legislation something we had never had before in Ontario, which was exemptions. So we set out the law, we set out a negative duty, a positive duty, and then we say, but this law doesn't apply to anybody who is involved in generally accepted practices of animal husbandry. This law doesn't apply to certain prescribed activities which are set out in regulation. So in this way, we got really progressive laws that are now excluded from applying to the violence that is caused to the overwhelming majority of animals in the province. So they're great laws with very limited application. Now, when it comes to pets, we have the same problem that we had in respect of the criminal code. These pets are on private property. So who sees them, who finds out about them, all of the things that I just mentioned. This legislation as well, in most cases, is remedial rather than preventative. In other words, we're waiting to hear about a problem. Now, there is actually some power to the Humane Society to go out and to investigate, to make sure the standards of care are being complied with, for example, in the course of some industries. But that wouldn't apply to private pets. The Humane Society is not going to just come knocking at your door to say, hi, we heard you had a gecko. We're here to make sure you're complying with the standards of care, right? They don't have the resources. It's not their job. It's not their authority. And by the way, they're not entitled to come into private property, even if they have suspicion that an animal is in distress, without getting a warrant. And the lack of veterinary expertise that I mentioned in respect of the criminal code is also a concern in respect of the OSPCA Act. And there's an inherent difficulty of proving animal welfare and animal cruelty offenses because of the vagueness in the legislation, because of all of the things that you've heard about all day, all the range of conditions that these animals will experience that even experts in the field may not be able to identify. Humane societies, if you think about it, humane societies are given a huge job. There's a giant expectation put on them that they're going to deal with all the animal welfare in the province. And they're going to do it with the funding they get from their bake sales on Sundays, right? Like, they get some money from the provincial government, but they have a very hefty duty on them. They're not sufficiently resourced to do all the investigation that's expected of them, and the law limits their power to do so in many cases. There are no rules in the legislation, by the way, which are specific to the mobile live animal displays that are becoming so much of a scourge across this province. And it's very hard to pin them down. It was a problem with circuses for many years as well, because they're traveling, so they're not in one jurisdiction long enough for anybody to talk about a specific length of time, like the way Cliff said, I think it was Cliff who said just earlier, oh, well, this enclosure's temporary. Well, when you think about how much temporary time the animal spends there, it ends up being quite a lot of their life, but they're always moving, there's chunks of time. There are all sorts of challenges inherent to a mobile display that is constantly on the move to try and make laws stick in respect of it. And so that brings me to municipal law. Now, municipalities find themselves sometimes in a position where they want to or are pressured to respond to try to fill in some of the gaps in the federal and provincial legislation. And municipalities do have the authority to pass bylaws with respect to keeping animals within their jurisdiction. And there's a whole range of them across the province and across the country, all different kinds. Municipalities can also have a registry of exotic animals, right? Like licensing, the way you license your cats. Although our experience, our understanding is that these registries tend to have very low compliance rates, even lower than cats and dogs, but it's a possibility that municipalities can look at. Now, there's downsides on relying on municipalities to fill the gaps left by provincial and federal legislation. It's patchwork, right? Because there's so many municipalities. So it's tiny jurisdiction and patchwork. And municipalities have enough to deal with in all of the things that they're expected to regulate on and can't be expected to have expertise in respect of the wide range of exotic animals people are keeping as pets. Enforcement is expensive. What money do they have to do that with? And the low registry uptake, as I just mentioned a moment ago, people do not get their turtles licensed in our experience. So it's tricky. But I do want to say there are times where municipalities can do something really important. And sometimes we just need one trailblazer to stand up, to take a stand, to have the nerve to stick to it. So Richmond, BC was the first municipality in Canada to pass a bylaw to prohibit selling cats and dogs in pet stores. And the pet industry went nuts about it and took them to court and lost. And as so often happens when we hear industry say, you can't pass this bylaw, it's going to destroy us, well, the bylaw survived the court challenge, and sure enough, of course it didn't destroy the industry. Of course industry has just responded and done just fine. And now we see other municipalities, now that Richmond stood up and fought the court challenge and the bylaw survived, other municipalities, including this one, now have the strength to prohibit selling cats and dogs. And what happened? The pet stores aren't out of business because the pet stores, it turns out, weren't making any money selling cats and dogs anyways. They just want cats and dogs in the store because that's what brings people in. So now they have cats and dogs for adoption. And guess what? Business is booming. So good on Richmond. Hudson, Quebec, to go east. Hudson, Quebec was the first municipality in Canada to pass a bylaw prohibiting spraying pesticides on your lawn. And industry said, it's going to kill us, we're going to go broke, and challenged them in court. And the case went all the way to the Supreme Court of Canada, where the Supreme Court said, 20 years ago, nobody even knew about dangers to the environment. Nobody was talking about these things. And now environmental protection has emerged as one of the most precious values to Canadians and upheld the bylaw. And now we have jurisdictions all across Canada that have now had the nerve to pass similar bylaws themselves. So municipalities can do something really important. So I want to just spend my last couple of minutes talking about two options. Because the law has such a hard time really protecting animals, and because when it comes to exotics who have such specific and varied needs, it's even harder than it is in other circumstances. There are two ways of considering approaching this problem that may be much more effective than trying to deal with the particulars of trying to address animal welfare for these wide range of species. Option one, prohibit keeping and selling exotic animals. And option two, introduce a positive list. So to talk about the first one, to end the exotic animal trade. Now, I understand, I've heard the talks today, I've seen the pictures. There's innumerable animals living in plastic containers on people's walls or in tiny little holes in their basement or backyard. There's so many animals, we can't begin to count them. So to stand before you and say, let's just end it, I understand that that might sound simplistic, but we have to start somewhere. And the question continues to press as science keeps telling us more and more about what these animals are really experiencing when we keep them confined. What's the justification for doing this? Do we have a justification for doing this? And to the extent that communities think that they don't want, whether it's the animal suffering or the danger to human health and safety that these animals present, and decide that they want to stop, a prohibition against trade is possible. It's comprehensive. It's obviously the strongest protection for wild animal populations. It eliminates what are inevitably poor welfare outcomes for captive exotic animals. It protects public safety. It gives clarity in enforcement. And of course, it eliminates the need for local veterinary expertise on exotic animal welfare, which is expensive and hard to come by. The second option is a positive list, where jurisdictions say, we're not at the point where we're going to talk about prohibiting keeping these species, but what is the most efficient way of trying to regulate the way we're going to do it? Now, what municipalities and other jurisdictions have been doing for a very long time is a negative list. You are not allowed to have the following animals. But negative lists, and I think you've already heard something about this, I missed the early part of the day, I apologize, but negative lists are really problematic, right? Because you still need the experts there to distinguish between a wide range of species, which is a problem in and of itself. There's uncertainty, there's always new species coming, where a positive list is very clear. And it's a new approach that's becoming very popular. It's like it's an idea whose time has come. a concise list of species that are permitted. Belgium has it, the Netherlands has adopted it, other EU countries are moving in that direction, and New Brunswick. We don't even have to be the first jurisdiction in Canada to do it. New Brunswick has a positive list model in place in their exotic wildlife regulations. So it's a really safety-conscious way of proceeding. It's preventative and precautionary in nature. It's very easy. It's an evidence-based approach to welfare, because if the industry is so concerned that people in Ontario must have a specific animal, let the industry gather the information to persuade the appropriate government level that it's safe for humans to interact with these animals, that it's safe for these animals to be kept captive in our homes. So it's definitely an easy, clear way to regulation. Where negative lists, as I was saying earlier, can be cumbersome and complicated and are constantly in need of revision, something that is well beyond the capacity of most municipalities and, frankly, provinces too, who have plenty of work to do on just the human problems that we give them. So those are the two options that are being actively promoted in the animal welfare world now. And I think I might stop at that point and just see if you have any questions about any of the whirlwind tour we just did through animals and the law.